Well, thank you for joining us again in Media Law. Last time we looked at an introduction to defamation and the basic rules surrounding defamation, the law around the reputation, what one needs to do to sue somebody or even have criminal prosecution against someone over the damage to their reputation. But the media are all about trying to publish as much as possible. And sometimes we do need to publish all sorts of things which might damage people's reputation, but for very good reason. So in this module, we'll look at defamation defences, which are crucial to producing good, strong, bold journalism in a democratic society. The background to defamation defences is that they do vary markedly across different countries in different jurisdictions. In fact, they even differed markedly throughout Australia until defamation laws were made almost uniform in 2005 across the different states and territories. But internationally, you find huge differences in what can be defended in defamation cases. In America, there is the First Amendment to their Constitution, guaranteeing press freedom. And this has informed their defamation laws, particularly over the last century, as the textbook explains. In some other countries, there's the other extreme, where it's very difficult to defend a defamation accusation against you because the laws of the country are stacked against the media. In some places, there is still criminal defamation, even in some parts of Australia. But in some countries, this is actually pursued all too often by governments defending their senior officers against media scrutiny. Well, let's take a closer look, in brief, at defamation defences in Australia. And there are three main defences journalists particularly need to remember to go about their work on a daily basis. Now this, of course, also applies to public relations practitioners and others working in a daily or a frequent publishing environment. Now the first big defence is truth. And truth as a defence sounds fairly simple to prove. If it's true, for example, that someone told you something, you'd think you'd be able to prove the truth of what they said. But unfortunately, the problem with truth as a defence is that if you're publishing material, you need to prove more than just the truth of what somebody told you, the truth that they told you. You need to be able to prove the substance of whatever allegation or imputation they're making about someone. And that can be quite different from just simply producing a recording of someone telling you something. Even if you put it in quote marks, it's not enough to be able to prove the truth of what's within those quote marks. So if you're doing a story which damages someone's reputation in some way, you need much more than a quote from somebody saying, proving that they told you. What you need is evidential proof, evidence that proves the facts around which the allegation is being made, but also that proves the meaning coming from those facts. So let me give you a quick example. Just say, for example, you were to produce a photograph in an online outlet of a prominent politician receiving money from an underworld figure in a restaurant. Now, the fact is that transfer of money may well have taken place. The photograph is clearly these two individuals, the politician and the underworld figure. But without knowing more about the circumstances, it carries the imputation that the politician is corrupt and perhaps is involved in some conspiracy or some crime with the underworld figure. If you were to run on that basis, then you could still be in serious trouble for defamation. Think of all the possible circumstances that might be at play. The politician may be part of some entrapment exercise involving the police and may be totally innocent of any corruption. The figure that's involved may have bribed the politician in some way, and it may be subject to police scrutiny, and the politician may be actually bringing extortion charges against the underworld figure. He may not be part of some conspiracy. So, to that end, if you did want to run with a story about the politician being corrupt, you would need much more evidence that actually could prove in court, evidence that's admissible in court to show that there is this actual conspiracy and the politician is corrupt. That could be other photographs, testimony from people who are willing to swear in the witness box in court, perhaps recordings, documents, all sorts of other evidence. So truth as a defence sounds simple, but the textbook explains these shortcomings and gives several cases to underscore that. The second main defence that journalists need to know about is the defence of fair comment or honest opinion. Now, this is the basic defence that's used by those in the media who are producing commentary and opinion. An editorial in a newspaper, a column by a blogger, perhaps a section of quotes with expert opinion in a news story. All of these can be defended by the fair comment defence. The textbook explains several criteria that need to be met, though, in order to meet this fair comment defence. The comment needs to be on a matter of public interest, something out there in the public domain, not about some private matter. It also needs to be fair and honest. So while it could be an extreme opinion that defames someone in some way, as long as it is reasonable that someone might hold that extreme opinion, that's okay. So the opinion itself can be defamatory and damage someone's reputation. This person is a poorly performing politician. This person should be sacked as a first-grade referee. This opinion has to be founded, underscored, scaffolded by provable facts that are stated there in the opinion material. And that's the shortcoming. With so much shorter media these days, for example, Twitter, it's very hard to have the provable facts there in the material when you're publishing a scathing, defamatory opinion about someone, their work, or their performance. It also has to lack malice or be published in good faith. So if there's some reason, perhaps your own company you're working for has some commercial interest in you criticising somebody, you might lose that good faith part of this defence. Now, there are several good examples in the textbook, some to do with restaurant reviews that went wrong. So have a good read of those cases and listen up in the lectures for that kind of detail. The third key report that journalists need to work to particularly is the fair report, or the fair and accurate report defence. And this defence covers court cases, parliament, public occasions where journalists have to go out there and report, as we learned through our open justice modules. Journalists are almost obliged to cover the court system. They have an obligation to society, and many, many defamatory things are said in the courtroom and in Parliament. But as long as these reports are fair and accurate, they are protected by this fair report defence. There are other shortcomings to this defence that you'll need to read about in the textbook, but you can see how those three defences pretty much cover much of what journalists need to do in their work in publishing good, bold, strong journalism that might damage some reputations. If what they're publishing can be provable as true, they've got that defence. If it's an honest opinion or a fair comment, part of the opinion sections of media outlets, they have that defence. And if it's a fair and accurate report of what's happened in court or Parliament or many other important public occasions, then they will have that crucial defence. Now, there are other defences that are useful to journalists, and these defences are also covered in the textbook. But it's those three that journalists particularly have to remember, because the other defences really do need good, solid legal advice, particularly on the biggest investigative, hard-hitting stories. And one of them that's explained is the defence called qualified privilege. And this is where you can't quite prove the truth of a very serious allegation, normally to do with something really going to the central workings of society, something to do with a corruption scandal or some public matter that's gone seriously wrong. You may not be able to quite prove the truth of it, but there's an overwhelming public interest that meets certain criteria explained in the textbook that excuse your publication because it is so overwhelming in its public interest factors. Now, in the Defamation Act, those criteria are set out very, very clearly, and you can read those in detail in the textbook. And I think when you do read them, you'll see why legal advice is paramount when trying to work within the qualified privilege defence. Now, we learned earlier in media law about some High Court decisions through the 1990s which implied a constitutional freedom to communicate on matters of politics and government. And this has been read into some of the defamation defences. And several important cases stated in the textbook actually centre on what we call political qualified privilege, or the Lange defence. Essentially, this means that there is a defence available in qualified privilege which is a little more lenient to the media if they are engaging in reputational damage as part of a robust discussion of politics and government. Now, the High Court has not clearly defined this defence as it applies to defamation. So again, it's one that requires very sound legal advice, and it could even go to the High Court as an appeal. It's not one you would test as a modest freelancer or in a small media outfit that can't afford that level of appeal. So the mainstream media organisations are left to test the boundaries of the political qualified privilege defence. Importantly, there are other lawyers' defences to defamation that are mentioned in the text. One of them is the offer of amends, and journalists and editors do need to know about this, because if that's followed properly on legal advice, it can nip in the bud a defamation allegation or a developing defamation case by making a quick apology and offer within strict terms defined under the Act and done on the advice of lawyers. Some other lawyers' defences are the defences of innocent dissemination and triviality, which the textbook explains. There are other important issues related to defamation defences, and you'll need to refer to the textbook for those. They are issues to do with malice and what the Americans call absence of malice, which is a crucial part of the US media defences to defamation when they've defamed public figures. But in Australia also, malice or a lack of good faith plays an important role. There is also information there in the text to do with the different remedies that might be available in defamation cases. Of course, the main ones are damages, an award of damages, or court-issued injunctions stopping you publishing more on that matter. There's also the important area of criminal defamation, which I mentioned earlier and still exists on the books in some parts of Australia and other countries, but it's rarely used, so it doesn't become a prominent part of our studies. And there's the related area of injurious falsehood, which is a situation where companies can actually sue. Normally companies, larger companies, can't sue for defamation, but they can sue for injurious falsehood. And that's where you might knowingly publish something that clearly is a falsehood that damages a company's interests, and it's a different action with different elements to it. Well, that's a defamation defences in a nutshell. It's a very complicated area, so you really will need to read the text and workshop the other learning activities carefully. Don't forget your basic study plan to start with this mini lecture and to work into the other activities. We'll see you next time.